statute of Ghana, if that is not a miscarriage of justice, respectfully, I do not know what is a miscarriage of justice. Section 72 is very simple in its terms. Section 72, subject to the discretion of the court in a civil action a party or a person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. Yet, this is what your lordships say in your ruling. At page 5, your lordships say, the question is, how can the chairperson of the first respondent vindicate herself when she is not on trial before us? She has neither been personally sued nor arraigned before this court on any complaint or accusation for which she has to explain or account to anybody. It is the institution, the Electoral Commission she heads, that has been accused by the petitioner of not having performed his role. Now, my lords, I mean, respectfully, that is not even true. We have respectfully brought the attention of this court, her failure, her singular failure to perform her roles. We do not simply come before this court talking about the first respondent as a commissioner. We specifically have raised issues. The heart of this case is about her declaration. But these are the questions. And then your lordships go on. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary defined a hostile witness as so-and-so. There's a whole quotation from Black's Law Dictionary. Then it carries on, in effect, to say that it is only when a witness is in the box that he can be declared a hostile witness. My lord, that is not the law of Ghana. The law of Ghana is not what Black's Law Dictionary is saying, or what their lordships based on Black's Law Dictionary are saying. The law of Ghana is what I read from section 72. That says a party may be called. A party may be called. It's not that when they are in the witness box, then they can be turned into a hostile witness. That is not what the statute law of Ghana says. And my lords, it is fundamental and egregious error when on the basis of Black's Law Dictionary, we have the courts of Ghana going against a statute of the land. Ground B of our application, of our grounds. Ground B says that the ruling was in fundamental error in subjecting statutory provisions in the Evidence Act to the provisions of subsidiary legislation. My lords, there again, nothing could be more basic. Nothing could be more basic than the fact that a statute is superior to subsidiary legislation. The Rules of Court Committee are not of a higher standing than the Parliament of Ghana. And so when you have a judicial decision of the highest court of the land effectively subjecting Parliament's law to the Rules of Court Committee, that is fundamental.
Mr. Chikata.
Yes.
Are you suggesting that CIs do not go to Parliament?
CIs go to Parliament, but they go to Parliament in a different way from how statutes go to Parliament. That is why the Constitution makes a distinction between the exercise of powers by people such as the Electoral Commission, who take the CIs to Parliament, and if there's no objection, it goes through. That is a different process from a statute, which is an act of Parliament which overrides subsidiary legislation. My lords, there can't be any question. And if your lordships have an issue with that, I'm afraid that that is just fundamental error. There can't be any question that subsidiary legislation, such as is contained in a constitutional instrument that brings into effect what the rules of court have done, there can't be any question that those are subordinate to the Evidence Act. There can't be any question about that. So where in your ruling your lordship say that you're not going to apply the Evidence Act because there is a rule of court, and that rule...
Isn't that the exercise of our discretion which prefaces the section that you read?
My Lord, those are not the terms of the ruling. The terms of the ruling that your lordships gave, the terms of your ruling are very clear. And unless the ruling is being rewritten, the terms are very clear. Namely that the evidence section 20, we wish to state that, this is at page 10 of the ruling, we wish to state emphatically that section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38, Rule 3E5. That is what the ruling says. It doesn't say that in the exercise of my discretion, this and that. It doesn't say that. It just says it is not applicable. That is what it says. Nothing more, nothing less.
Mr. Chikota?
Yes.
Do you have a list of everything that the panel took into account before coming to that conclusion?
It is a ruling of the panel that we are here to question. And the ruling in its terms is what is before us. Obviously, I'm not in the minds of the panel, and I'm not able to divine whatever went on in their minds, except by reference to the terms of the ruling. And my lords, in any event, Order 38, Rule 3E5 has nothing whatsoever to do with application of the Evidence Act, Section 26. Order 38, 3E5, it reads as follows, that is as amended by CR 87. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. That provision has nothing to do with the Section 26, which the court was stating emphatically is not applicable because of this order. The terms of this order are themselves very clear. They do not have anything to do with what Section 26 says. What Section 26 says is, again, not controversial. What Section 26 of the Evidence Act says is simply establishing a conclusive presumption in a circumstance where somebody has put before the court clear indications by way of affidavits that she will be available to be cross-examined. That leads to what Section 26 describes as a conclusive presumption based on the estoppel by own statement in Section 26, except as otherwise provided by law, including a rule of equity, when a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest, and such relying person or his successors in interest. Order 38, 3E5 has no relevance in terms of that. And our submission is simply that the court cannot sideline the operation of a statute by reference to subsidiary legislation, which in any case has no relevance to the issue of Section 26. My lords, we indicate in ground C, in ground D, so we've dealt with A, B, and C. We indicate in ground D, we take B and C together. And I argue in relation to B and C that the fundamental errors consist of sidelining legislation in favor of subsidiary legislation, and in relation to ground C, sidelining it in favor of subsidiary legislation which is irrelevant to the issue in the statute anyway. And so we move to ground D. And in ground D, our submission is that here again, the court made no reference whatsoever to Order 38, Rule 10 of CI 47, nor indeed Section 58 of the Courts Act. And Section 58 of the Courts Act is a section which even gives power to your lordships to call a witness. And that section has been properly applied. So in other words, apart from our ability to subpoena upon reopening of our case, apart from that, there is also the opportunity for this court itself to call a witness. And the circumstances in which the court does that, those circumstances are exemplified in the case of Wardier and Bukhari. Wardier and Bukhari, 1976, 2 Ghana Law Reports, 371, where the Court of Appeal, the then Apex Court, proceeded as follows. And this is from the judgment of Justice of Appeal Archer, as he then was. After judgment had been reserved in this court, it was felt that this court should not be placed in the same situation in which the court below found itself. It was therefore decided to ascertain the truth in this matter, and so on. And based on that, the court had recourse to the Courts Act to ascertain the truth of the matter. And then the court went on to point out that just that invitation of the witness to come and testify had brought up a very important piece of evidence, which, if it had been adduced in the court below, would have spared that court the torment of exploring whether or not the certified true copy of the plan from the Lands Department was the plan tendered before Jackson J. And the court even goes on to say one can understand Mr. Joe Rindolph's initial reservations, but as this additional evidence has enabled this court to ascertain the truth beyond all doubt, we think by allowing this additional evidence to be admitted, Mr. Rindolph conducted himself in the best traditions of the bar. Indeed, those words in respect of the best traditions of the bar evoke some nostalgia in the hearts of some of us. And my lords, we are respectfully saying that the ruling that your lordships gave did not even advert to Order 38, Rule 10, which we had indicated was the basis on which we were seeking to reopen our case. It didn't even advert to that, and it was therefore per incuriam. We say also in ground E, which I move on to now, that the ruling was per incuriam Article 1913 of the Constitution and has occasioned a grave miscarriage of justice. And Article 1913 is the provisions on the right to a fair trial in this court. And we show in our submissions on that matter how this Supreme Court adverted its mind to a decision of the Supreme Court of the Netherlands, in which the Supreme Court of the Netherlands was highlighting the importance of ascertaining the truth in matters that were before it. And that was made to displace, in the interest of the right to a fair trial, it was made to displace even international relationships as being something that the court would have reference to. That decision in the case of Chachuchikata and the Republic is a decision that we have cited in our submissions, and I will not go further into that, except to underline the fact that the Supreme Court of the Netherlands, whose reasoning was adopted by the Supreme Court of Ghana, also considered it appropriate that in the interest of ascertaining the truth, it was of value to the court to call a witness.
Once again, I'm curious about something. If it was so important to you to have a particular person testify for you, why did you not present that as part of your pre-trial positions?
My lords, we could not, for the reason that I've given a few times in this court. At the time, that first respondent's chairperson was the person who had filed a witness statement on behalf of, well, first of all, had filed an affidavit of verification of the case of the first respondent. Subsequently filed a witness statement on behalf of the first respondent. And my lords,
So in essence, you were hoping to rely on her coming to testify and found yourself without that. And that is why now you are asking that she comes as your witness after everyone has closed their case.
my lords,
Is that what you're saying in essence?
My lords, what we're asking is for our case, for us to have leave to reopen our case. That witness, as we've indicated, had sworn affidavits in response to our application for interrogatories, in response to our application for stay in relation to that. And in those, she had given every indication that she would testify. We had no reason to believe that she wasn't telling the truth. We had no reason to believe that she didn't mean it when she swore those affidavits. We had no reason to believe that anybody in the court would have assumed other than that she would testify. In fact, the day that it was announced that she would not testify, on that day, your lordship themselves expressed, some surprise. And that was the reason why you adjourned to the next day for arguments to be raised and so on. So, my lords,
Mr. Chikata, when you announced that you had closed your case, what did you mean?
nothing more, nothing less. We had closed our case. And when we announced that we are seeking to reopen our case, I mean exactly that, nothing more, nothing less. We're seeking leave to reopen our case in circumstances where a person who has deposed to affidavit saying she will be available for cross-examination, and where your ladyship specifically had intimated that the questions that we're seeking to raise in interrogatories could be asked of her in cross-examination. I'm sure your ladyship has not forgotten that bridge. And in that context, your ladyship had said that aren't we crossing a bridge that we have not got to? And we indicated that at the stage of interrogatories, we still found it appropriate to anticipate that. But your ladyship said the bridge will be there. That bridge is no longer there.
When you said that you had closed your case and you meant it, nothing more, nothing less, What did you mean?
I really don't understand what more your ladyship wants by way of an answer. We meant that we had closed our case. And we had closed our case, and subsequently we sought leave to reopen our case. Your ladyship cannot say that we are not able, under the rules, under your inherent jurisdiction, to ask for your leave to reopen your case. I don't believe that that is a suggestion that your ladyship is making.
I don't think I've said any such thing.
Yes,
So
but it's very difficult to comprehend.
I just wanted to understand what you meant when you said you have
I've
closed
answered that question, I
and
think,
you
twice
said
or
nothing
thrice
more,
already.
nothing less. And I'm satisfied with the answer, sir.
My lords, we continue finally to the last ground, that the ruling was in breach of Article 296. And my lords, very simply put, what we're saying is that that ruling is completely unreasonable in terms of what are often referred to as the Wensbury principles. And her ladyship, Justice Georgina Wood, as she then was, in the case of TDC and Musa against Atap Balfour, 2005-2006 Supreme Court Law Reports, page 121. Your ladyship's, her ladyship, at page 131, expressed the specific terms of what such unreasonableness amounted to. And by saying that he, that is the plaintiff in this case, succeeded in showing that the case fell within the irrationality or unreasonable rule, in that the decision arrived at by the TDC defies logic and common sense or accepted moral standards, and that without meaning any disrespect to the TDC, no sensible or reasonable person called upon to apply his or her mind to the decision to be taken could have come to that decision. In short, the decision to throw him out of the house and foist a residential plot on him is irrational and unreasonable. And we are saying respectfully that your lordships, in the exercise of your discretionary powers, unfortunately failed to advert your minds to relevant statutes, introduced irrelevant considerations which prejudiced a fair exercise of discretion as required by Article 296 of the Constitution. It is our submission that holding the first respondent, and particularly his chairperson, accountable for the exercise of powers conferred by the Constitution and statute justify, in the circumstances of this case, that that chairperson be called upon to testify using the time-tested subpoena procedure that we seek to invoke in this case. My lords, there is no question that the process of review is among the ways in which corrections are made by your lordships. And as Aqua...
Your time is up.
May I just finish in a minute, because I'm in the middle of a sentence. Is that allowed?
Okay. You may finish.
As Aqua indicated in the Koglex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear